Hey, I'm Simisola, arrested at 3:30 a.m., tortured, detained 7 months without trial, convicted and sentenced to death. Key prosecution witness never showed up for cross-examination. You appeal, court agrees trial was flawed but orders you to be tried again. 16 years have passed since your arrest. When does justice become oppression? This is David v's People of Lagos State, Nigerian Supreme Court. March 15, 2008, 3:30 a.m. Police came to David's house in Lagos. They brought another man who said he needed David to stand surety for bail. David agreed to help. At the station, police told him to write a statement. He refused. They pressured him for N$120,000 bail. He could only pay N$5,000. They took it. Then they took him to a room and tortured him. He was thrown in a cell from March to October 2008, 7 months, before being taken to magistrate court. Finally arraigned at Lagos High Court, April 2009. Charges: armed robbery and conspiracy. He pleaded not guilty. The trial: prosecution called 3 witnesses. 1. PW2, the investigating officer from Federal Special Anti-Robbery Squad, was crucial. But here's the problem: PW2 never completed testimony. He gave evidence, but before David's lawyer could cross-examine him, he disappeared. Never returned to court. Trial proceeded without him. September 2011. Trial court convicted David of armed robbery. Sentence: death by hanging. David appealed. Court of Appeal found serious problems. Prosecution failed to prove the offenses. There was breach of fair hearing. PW2 abandoned case before cross-examination. Trial was a nullity. Court of Appeal quashed conviction. But instead of setting him free, they ordered retrial before another judge. David had been in the system for years. Conviction overturned, but still not free. He appealed to Supreme Court. Supreme Court asked, was Court of Appeal right to order retrial? The law is clear. Retrial is not automatic even when trial is null. Courts must consider 5 factors. Was there error making trial a nullity? Yes. PW2 never cross-examined. Does evidence show substantial case against accused? No. Court of Appeal already found prosecution failed to prove offenses. Are there special circumstances making retrial oppressive? Yes. 16 years passed. Witnesses gone. Is offense trivial? No. Armed robbery is serious. Would refusing retrial cause greater miscarriage of justice? No. David's innocence was never disproven. Supreme Court held. Court of Appeal made critical error. It already found prosecution failed to prove the case. No substantial case existed. Moreover, 16 years had passed. Key witnesses, especially PW2, long gone. Nearly impossible to conduct fair retrial. Justice Umar quoted precedent. The length of time appellant had been incarcerated, difficulty of procuring witnesses. Courts should not be forum of oppression, but temple of justice and fairness. It would be oppressive to order retrial. Supreme Court decision: appeal allowed. Retrial order set aside. David discharged and acquitted of all charges, released from custody immediately. After 16 years, David was finally free. The lesson: if you're charged with crime, you have right to fair hearing, including right to cross-examine prosecution witnesses. If key witness disappears and you never get that chance, trial is fundamentally flawed. If appellate court finds prosecution failed to prove case, you should be discharged and acquitted, not sent back for another trial. For prosecutors, you must produce your witnesses. If key witness abandons case, accused has right to test evidence. For justice system, justice delayed is justice denied. 16 years is unconscionable. Retrial should only be ordered when there's substantial case, witnesses available, and it won't be oppressive. This reaffirms Section 36 of Nigerian Constitution, presumption of innocence. When prosecution fails to prove guilt beyond reasonable doubt, accused must be set free. If you're facing criminal charges or unfair trial, contact a criminal defense lawyer immediately.